Welcome to Stress-Free IEP. You do not need to do it all alone. With your host, Frances Shefter, Principal of Shefter Law. She streams the show live on Facebook on the last Tuesday of every month at noon Eastern. Get more details and catch prior episodes at www.shefterlaw.com. The Stress-Free IEP video podcast is also posted on YouTube and LinkedIn, and you can listen to episodes through Apple Podcasts, Spotify, Google Podcasts, Stitcher, and more. Now, here's the host of Stress-Free IEP, Frances Shefter.
Hello, everyone. Thank you for joining us for our show. Our next guest, I'm so excited because I'm going a little bit out. Our next guest isn't IEP related, however, very important for our special needs families. So Todd Boernstein, please introduce yourself. Tell us who you are, what you do.
Thank you, Francie. My name is Todd Boernstein. I'm an estate planning attorney with the law firm of SELZER GURVITCH in Bethesda, Maryland. I've been practicing estate planning for over 20 years, and I help clients with a wide variety of circumstances, and in particular with what we're talking about today, I have a lot of clients with children with special needs or family members with special needs, and that those families require unique planning to take care of them and to protect and preserve assets.
Thank you. And it's so important because, people don't even have their basic core estate planning documents together. At minimum, what should families have when they have younger children?
Right. So I recommend it, whether or not you have children with special needs or not special needs, but actually even more so when you have children with special needs, it's so important to have your core estate planning documents in order and complete. What are the core documents? So the first is a will. And so a will allow mom and dad to basically say where their assets are going to go when they die. Are they going to go to their children in equal amounts, or are they going to maybe set aside more for the special needs child? How is it going to go to the children? Is it going to go to them outright? Is it going to go into a trust for them? These types of things, if you don't have a will, then you don't have any say or control over that. And it's really a crapshoot. The other really important area is you appoint a guardian in a will. And so if something happens to you, mom and dad, they want to be the ones to appoint a guardian and a backup guardian who will be responsible for raising their children, and in particular, a special needs child. And so if you don't have that in place, then you're not choosing the guardian. You're leaving that up to potentially the courts. And you may have some family members and they think they want to be the guardian, and you may have other family members that may not. That could lead to conflict and fights. It's just best to plan ahead, and you know what's best for your children. You choose that.
Okay. Right. And I know picking a guardian, I was just going to say, picking a guardian is hard. I waited a while to do my will because my husband and I were not sure who to, it's hard to think of that as somebody else raising your children. But we finally said, you know what, we'll figure it out when it's time. We need to get the wills done. So you'll talk through with them, right?
It's very common. So many times I have clients that come in exactly like in your situation. They've had kids, and they may be 5-10 years old, and they just never got a will done. And why? A number one reason, they can't pick the guardian. So then they don't have anything. And so it's really doing a disservice and potential harm. So I agree. You come in, and it may not be perfect, but you at least have a will in place, and you pick guardians the best that you can. And again, once you sign it, you can always amend it. It's very easy at any time to come in and amend that one provision relating to a guardian, and then you can change that, as often as you like. But it's important. You got to get something in place.
Right. And so the two things, number one, who's the guardian of your children? But then the other important thing is, how do I leave money to my child? How do I know my special needs child is going to be cared for? Are there different ways that we can set up to leave money?
Yeah. So these are when clients come in, whether they've had something in the past or whether I'm doing something from scratch. But at a very basic level, you could leave a mom and dad could leave their money outright to their children. So let's say they have 3 children, and if they're young, let's say they're in elementary school, and they just say their will say, you know, I leave. Dad's will says I leave everything to mom, and mom's will says that if she later dies, everything will go to the children. And if you just sort of leave it at that, if the children are younger than 18, then it will go into a custodial account for them. And again, ideally, you would appoint a guardian who would manage that account. If not, then a court will appoint somebody who will manage that money, those custodial accounts for your children. Okay, but once they turn 18, they'll get the money. Okay, that's one way. If your children are older than 18, so let's say you have children in their 20s or adult children, and you leave the money outright, then it's just theirs. They get it, and that's how they get their money. For an adult that may have special needs, that may be a problem for a few reasons. One, the special needs adult, they may not know how to manage the money. And it's possible that they could spend the money, somebody could take advantage of them, it could be taken. So that is not really appropriate in that case, because you really don't want to leave money to somebody who is unable to manage it and protect it. Okay. A second option. So some people will say, well, I have 2 children. One has, special needs. These might be adult children. And older sister, she's great. She's an accountant or a lawyer. She's great with money. What the family says is, well, I'll just leave everything to the adult sister, to big sister, and she'll use the money to take care of the brother with special needs, so that will avoid the problems that we just talked about. She'll use the money for his benefit, and it will be protected. And that, in theory, is good. The problem is that if sister divorces, it's possible that the money won't be there to take care of brother if the money gets taken in a divorce. If sister is in a car accident, kills somebody, and is sued, it's possible that a creditor would take not sister's money plus the money that was set aside to take care of the other child. If sister dies unexpectedly, then the money won't be there to take care of the autistic child. The money may go to sister's husband or to sister's children in their will, and there won't be the money. So leaving it to a sibling is not a good way. The best way to make sure and ensure that there's money for your child with special needs is to leave it in a trust for that child. And if you leave it in a trust, then you can ensure there's a legal mechanism to ensure that the money will be there for that child and can only be used for that child.
So, and that's a regular trust. And I know a lot of people talk about a special needs trust. Is that something different?
Yes. So let me, that's a very good question. So special needs trust is kind of a broad term. And there are really what I'd say 2 types of special needs trusts that we talk about. So one is like the one that we just discussed. So mom and dad in their wills will say, when at the death of the survivor of mom and dad, a trust will be created at that time for child with special needs. And the provisions creating that trust are in their wills. The trust isn't created today. The trust is created and springs into existence at the time of the death of the survivor of mom and dad. Okay. And it's mom's and dad's money that is used to go into that trust. It's not the child's money. Okay. Those are what I would call third-party discretionary trusts. And I do those all the time. It's very common. And that structure is not only common for children with special needs, but even children without special needs. That's very common to structure something that way. Okay. There's another type of special needs trust, and it's referred to as a D4A trust, which refers to a provision in the federal code. And that is when it's the child's money that gets taken and put in a trust for the child's benefit. Well, why would a child have a lot of money? So this is the example. Child is born and there is some sort of a problem during birth, and there's a lawsuit, and child is awarded, $1 million or $2 million because there's a defect that causes, let's say, brain damage. And the child is actually awarded the money for that, not necessarily the parents. So it's actually the child's money. And in this type of trust, the parents working with the court, and you need court approval, will take the child's money and put it into this special type of trust for the child, and it's then used for the child's benefit during the child's lifetime.
So you say used for the child's benefit. Who decides how the money's going to get used?
Yeah, so let's talk about whether or not the trust was created with child's money or with parents' money. But let's use the example with mom and dad's money. So this is how the trust would work. So mom and dad are in a car accident and they both die, and they leave all their money in a trust for their special needs child. Okay. What they do is they will name a person who is called the trustee. And the trustee is the one they manage the money. They have legal access. So what the trustee would do is he'd open up, let's say, a bank account or a brokerage account at, let's say, Fidelity, a brokerage account at Fidelity, and a bank account at Bank of America. The trustee is the one who has legal access to those accounts. The trustee can write checks. He can decide how the money is invested. And most important, the trustee is the one that withdraws the money and spends it on your child with special needs when the child needs it. So if the child needs care or education or clothes or health costs, whatever the child needs, it's the trustee's responsibility to take the money and spend it for the child. So the child is the beneficiary of the trust, but doesn't have any legal authority to go and get the money and access the money him or herself. Now, the trustee, and so who are trustees? Well, typically mom and dad, what they might do is they may appoint a sibling of theirs, or like aunt and uncle for the child. Sometimes if they have adult children and one of the adult children has special needs, it may be appropriate to designate one of their other adult children who don't have special needs. Sometimes it may make sense, let's say there are no siblings or there are no close family members. Then there are professional trustees, there are corporate trustees, either at a trust company or a bank, that they are well suited. They have experience with managing trusts. And there are organizations that have particular experience in managing trusts for children and adults with special needs. And they may make a great trustee. The trustee can't use the money for themselves. They can only, so let's say you appoint, dad appoints his brother as the trustee for the child. Brother can't use the money for himself or his children or his family. The money can only be used for the child.
So trustee and guardian, if you appoint a guardian for your minor children and the money you're putting in a trust, do they have to be the same person?
Yeah, so that's an excellent question. This comes up all the time when I have clients that come in and they name guardians in their wills, and oftentimes we structure their wills or other documents so that they leave money in trust for their children. So the guardian's job, guardian sort of has two roles. One is there's a guardian of the person, and what their job is to make the life decisions for the child. They decide where the child's going to live, who the child's doctors are, when care, where they're going to go to school, all the life, anything related to the life and the lifestyle of the child. That is what the quote guardian of the person, that's what they are responsible for. Okay. If we don't have a trust and somebody left their money outright to the child, then there would be a guardian for the finances, the guardian of the finances for that child. And in that role, they would decide how the money is spent for the minor child until they turn 18 or otherwise have the ability to get legal control over it. Most of the time, they're the same person, okay? But there may be circumstances where it may be appropriate for maybe grandmother to raise the child and be guardian of the person, and because she's great at raising children, but she may not be good at managing money. And it may make more sense to have somebody else, maybe a sibling or a professional trustee, a corporate trustee, manage the money. And so, and again, back to whether it's the trust example, if you leave money in trust for a child, you may have a trustee that is different than the guardian who takes care of the child.
Right. And I mean, I know there's pluses and minuses for both, but you talk through with your clients on how to set it up and what their true desires are so that they can help determine, right?
I'd say, so practically speaking, I think all things being equal, it is easiest. And if you can trust the person to handle both, I think it's usually easier if you have the same person that manages the money and manages the person. Why? Because suppose the guardian of the child says the child needs private school, or the child needs this particular counseling or whatever. But if they have to go to the trustee and ask for the money to get those things paid for, and the trustee says no, well, then you have a conflict. So if they're the same person, then they not only can make the decision, but they will have access to fund whatever their decisions are.
Right. That makes sense. You know, but I'm thinking like sometimes, as you said, like the grandmother might be a good guardian, but might not be good with money. So that would be situations that you'd want different. And then also that there's the oversight that you make sure, because what happens if a guardian is in there and is misappropriating funds?
Right. So what will happen is, if it is two separate things, if there is no trust, let's say the parents just left their money outright to their minor children, then a court will appoint a guardian, and the guardian will be responsible for managing the money. Well, when there is a court-appointed guardian, you have to file an accounting with the court every year. So you have to account for the money, and the court will see what the beginning balance is and how the money was spent and what the ending balance is. Okay. If you don't have that, if you instead have a trust, there are also accounting requirements. So depending on the provisions that the lawyer puts in the trust, there are ways to provide safeguards for that. For other people on, let's say, siblings or other relatives that can act on behalf of the minor child to make sure to get accountings from the trustee, to make sure that, again, the trust funds are being spent for the child and not for the trustee or anyone else.
Okay, that makes sense. Yeah, because it's, like, okay, I'm giving all my children and all of this money, and how do I know they're not going to go buy, a new house and wherever and put their kids in private school?
Exactly. And that's really important. I will say, it's easy. All right, we'll just create a trust, okay? But in practice, really the most important choice, I believe, is the trustee. Who is that going to be? And at the end of the day, it really needs to be somebody that you can trust. And if you don't have somebody, and they, by the way, a sibling, let's say that mom or dad, they want to designate their sibling, one of their siblings, as the trustee. The sibling doesn't have to be a financial wizard. They don't need to know about how to invest, and they don't need to know all the legal ramifications of a trust. They need to be responsible and honest. But what they do need to do is they need to know to go seek advice. So as long as they can seek the advice of a financial advisor and hire a financial advisor for the trust, and they seek advice from a lawyer regarding managing the trust, that's all that's important. They don't need that extra knowledge. They just need to be responsible and caring and honest.
That makes sense. And if they don't know how to do it, ask the professionals. That's why they're there.
That's exactly right.
So we've talked through a lot of stuff on creating a trust and what you need to think through. What are if you were to narrow it down and say, okay, you're creating a trust, these are the top 4 things that you need to think about. What are those things?
Okay, so again, the situation is, let's say mom and dad, they have children, and one of the children has special needs. And at the end of the day, the key is if something happens to mom and dad and they are no longer around to care for their child, how is their child with special needs going to be taken care of and financially when mom and dad are no longer around? Okay, so one, again, you got to choose the right guardian and you got to choose the right trustee. Who is the person and the trustee who shares your beliefs and is going to spend the money in the trust in a manner that you think is best for your child, not only when the child is young, but in the future when the child is older. Okay, so the trustee is a major consideration. Okay, the second is what assets, what's going to fund the trust? So mom and dad, if there's really only a limited number of resources, okay, there may be their house, they may have some life insurance or retirement accounts or a brokerage account. How is it going to be divided? If they die, are they going to leave everything equal 50% to the healthy child and 50% to the child with special needs? Or do they want to maybe leave more money in a trust for the child with special needs than maybe the other child? You have to look at the facts and circumstances. Maybe the other child it has a very good profession and may not need an equal share of the money. Okay. Sometimes there may not be enough money and enough assets that mom and dad have. So they may, in that circumstance, they may want to consider buying life insurance. And that may be a way that if you buy a certain type of a policy called the survivorship policy that only pays at the death of the survivor of mom and dad, the premiums on that are relatively inexpensive compared to other types of insurance. And that way, that money can fund and that money can be used to go into this trust to provide a nest egg and a fund to carry the child through, at least through college or getting raised or adulthood. Another important consideration is, where is the child going to live? So let's say there's a minor child or even an adult child and they are living in the family home with mom and dad. That's not uncommon. Well, that's one of the assets is mom and dad, or maybe what they want to do is say, we're going to leave the home and we're going to make sure that the balance of the mortgage is paid off. And we're going to leave that in a trust for the child with special needs. and that's going to provide that child with a place to live for the rest of their life. We're going to make sure that we provide the child with the home. And then you can say, after child's death, whatever money's left, maybe that can then divert back to the other child. So it's important to consider what assets and how you're going to fund the trust, and make sure that it has enough money to take care of your child and do the things that you want to do.
Got it. And then you were saying before, like the healthy child or the child with special needs, because children with special needs, it's such a broad spectrum that it could be medical needs, and it could be intellectual issues, it could be physical issues. There are all sorts of special needs. Does that change anything of how you would put a trust in place?
Yeah, so it depends. In Maryland, if mom and dad leave money in a trust for their child, and let's say it's a child with, again, let's say somewhat drastic special needs, that really need a lot of care. They need a place to live. They need a lot of care. The provisions that are going to be in that trust, the provisions that kind of set the rules for how the trust funds can be used, they may be different than what the provisions would be for leaving money in trust for a healthy child. And that's really where you need the expertise of a lawyer who deals with this to work with the family to determine what provisions are appropriate. Okay. What I didn't talk about before, but it's very important. A lot of times, if children with special needs, depending on the extremity of it or what they are, oftentimes may qualify for public benefits. Okay, they're receiving either Medicaid or assistance, the ability to live somewhere, public housing, health care. And oftentimes, if the child, adult child, has resources of their own, then they're not going to pay for the public is not going to pay. They're not going to qualify for public benefits. So if mom and dad just leave their money and it goes outright to their child, then maybe the child doesn't have severe disabilities, but has enough disabilities that they may otherwise qualify for certain benefits. If mom and dad leave the money to them outright, that may disqualify them from receiving benefits. So another major benefit is when the mom and dad leave that money in a trust for the child, it's not the child's money, it's in trust. And if the trust is written in a particular way, then that money will not disqualify the child from receiving public benefits. And that money can be there to pay for things that the child might need that would not otherwise be covered from the public benefits.
So it supplements it. Yeah, I was going to touch on that also, because I know like a lot of our children wind up with SSDI and Medicare and so forth. And I've heard of situations that families didn't have a will and money went to the child and all benefits get cut off. And then Where are you? So I know you said, I'm thinking listeners, like parents, they always say, of course, attorneys are going to say hire an attorney to do a trust because we're attorneys. But there's a reason that LegalZoom won't work for this. Why do you really need an attorney?
Yeah, the reason is that there are really specific rules. Trusts are complicated. So there are tax when you create a trust, there are tax implications. You want to make sure that in order to get the protections that we talked about, having the money in the trust, not disqualify the child from receiving benefits, the trust has to contain certain provisions, and it can't contain other provisions. And if you get something online and it doesn't contain the appropriate provisions, then you haven't accomplished what you wanted to accomplish. Trustees, you want to make sure that there are mechanisms in place to have the trustee that you want be designated. But if something happens to that trustee, you want to make sure that there are mechanisms and provisions in the trust to appoint successor co-trustees or to fill a vacancy if all the trustees aren't around. I think there's too much at stake, and it's too important of an issue when you're talking really about the long-term care of your child to try and do this on your own. It would be very difficult, I think, for somebody who doesn't have knowledge of the rules and the laws to be able to do this in an effective manner.
And then, of course, the biggest problem is if you don't do it right, what happens?
Yeah, I mean, well, if you don't do it right, so like children with special needs, if they are, let's say, receiving benefits, what's required is you have to, when you apply for benefits on the form, that the application form, they're going to say, are there any trusts? They're going to say, what resources are available to the person applying for benefits? So all bank accounts, brokerage account, whatever it is. And they're also going to say, well, is the child, are they a beneficiary of any trust? And if so, how much money is in it? And we want to see a copy of the trust. And they'll read the trust. And if the trust isn't written and doesn't have the provisions in a certain way, it's possible that the trust, it will not protect the assets, and that the trust funds will have to be used for the care of the child and disqualify the child from receiving public benefits.
Right. And these are things that you wouldn't know until
they
actually kick in, unless you've talked to an attorney.
Exactly.
Yeah. I mean, it sounds complicated. I'm an attorney, and I know I had you do mine because I'm a special ed attorney. I don't know estate planning, and it's a lot. It's a lot to know, and again, not every attorney knows how to do it and knows how to do it
right. And that's why if somebody has an IEP issue, well, they need to see you. Attorneys, they specialize in things. And even all the concepts that I talked about today, while we focused on children with special needs, really I do very similar types of planning for children and family members that don't have special needs. It's a lot of what I do and other estate planning attorneys do is they try and when mom and dad leave their money to their children or to other family members, structured in a way to protect against creditors and divorce and minimize taxes. So that many of the same techniques that I would use to protect and plan for a child with special needs also apply to other family members, even without it. But with children with special needs, there are accelerated and additional issues and things that really need to be taken care of and taken into consideration.
Right. Yeah, that's so true. Something that came to mind was setting up trust in this. What my father used to say is that the trust allows him to control his money from the grave.
Yes.
Cool.
And a lot of times that's appropriate. Okay. And in particular, maybe with a child with special needs, but in other times, maybe that's not appropriate. So yes. And so that's another important point. You can create a trust and you can pick the right trustee and you can fund it with an appropriate amount of money. But then what are the provisions of that governing the trust? So the trustee has a set of rules. And those set of rules are, how can the trustee spend the money? Are they given broad discretion to use the money for the child in really whatever way the trustee thinks is best? Or has mom and dad in their will been very specific about the ways that the trustee can use the money? Which is like, in your case, ruling from the grave. They are telling the trustee, you can only spend the money on these specific things and limited to these particular amounts.
Right, because I've seen trustees get a little creative of like, well, the child needed to go on this fabulous vacation. And of course, we had to go with the child. And so the money's getting spent on that. and
Right.
instead of on college or healthcare or whatever else the parents would have wanted the money
Yeah,
to be spent.
exactly. And so the things that you're talking about, those types of provisions are very common in what I'd say boilerplate perform documents. So a form that you might pull off Zoom or on the internet, they may in the back, sort of buried in there, may contain certain provisions like that you're not aware of. And so, and sometimes that provision similar to that might be appropriate. Okay, it may be appropriate in certain circumstances if you have a guardian taking care of your child and you want your child to be able to go, on trips places or to go to summer camp. Well, it may be appropriate. Let's say you left them to your sibling and they have a child. Well, it may be appropriate to send, to put in the trust agreement or put in the provisions that the money that if they send one child, that their child with special needs to camp, that they can also send the guardian's children to camp. So that sort of as a family, they're treated as a family. That's not necessarily an unusual provision. But the point is you need to discuss it with your clients and do what they want to do.
Right. And then that's the other thing is if it's going to the court, a trustee from a court might not allow for the sibling, for the cousin or whoever else, the child's family that's living there might not allow for that. And so then,
And they haven't, again, the whole key is you want to put in place a plan and trust provisions that accomplish what your particular objectives are and what your wishes are and how you want your child to be raised. And that's why it's important for you, mom and dad, to set it up in the way that you want so that if something happens to you, whoever that is taking care of your child and responsible for your child's money, they are raising your child and using your money for your child in a manner that you would like.
Right. So I'm getting the key takeaways of get your estate planning documents done as soon as possible. Speak with somebody, even if you don't have who your guardian or trustee is, speak with an attorney to get that planned out. And then, of course, use an attorney, because if it's not right, it's the ramifications for a trust not being done right, or even your will and all the other things not being done right, are just, it's not worth saving a dime here that's going to cost thousands upon thousands potentially later if it's not done right. So how can people contact you, Todd? Like how should people reach out if they want to discuss their estate planning?
Oh, okay. Well, you can reach me. I'm on the internet. So my firm is SELZER, SELZER GURVITCH, GURVITCH, SELZER GURVITCH in Bethesda, Maryland. My name is Todd Boernstein. You can Google me and you should be able to reach me. My email address, if you want to email me, is tboernstein@sgrwlaw.com. But again, if you Google me online, you'll see my information.
And we're going to have the links in the show notes and
Great.
and everything. Todd, thank you so much for coming on the show.
Thank you for inviting me. This is fun. Thank you.
Yeah, it was a lot of fun. It was different. It was not, because it's not my usual of the IEPs, but it is something so important for the families, for all families with young children, that it's important. If you want to decide, if not, stranger, the judge on the bench, whoever that is, gets to decide. So thank you, Todd. It was great having you.
Right. Thank you very much. And I guess I'll see you Friday.
Yep, I'll see you Friday.
All right, thank you.
You've been listening to Stress-Free IEP with your host, Francis Shefter. Remember, you do not need to do it all alone. You can reach Francis through shefterlaw.com, where prior episodes are also posted. Thank you for your positive reviews, comments, and sharing the show with others through YouTube, LinkedIn, Apple Podcasts, Spotify, Google Podcasts, Stitcher, and more.